Yes.
Okay. I really appreciate it. We've had.
Oh, that's mom. Hey, mom, I have to go, okay? All right. Yeah, all right, bye, mom. Bye-bye. It's okay. All right, court is going to call 2024 CR 0282, State of Texas versus Dana Waters. Can I have parties announced for the record for the state?
Hank Wilkins for the state.
Defense?
Christine Brown.
And are you Miss Waters?
Yes, ma'am. Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Ms. Waters, I'm going to show you what's entitled Application for Community Supervision. She needs to sign it. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes.
State, are you proceeding on the indictment as presented?
We are, Your Honor. We're also proceeding on the repeat offender against an allegation.
All right, and you're proceeding on both counts?
Yes, ma'am.
Going to show you what's entitled Court's Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the state proceeds and is able to prove the repeat offender enhancement allegation, then in count 1 and count 2, your range of punishment will be anywhere from 5 to 99 years or life in prison. Did you understand?
Yes, Your Honor.
If you have a plea with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Waters, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, you'd agree that you've been convicted of a previous felony for purposes of enhancement. Punishments be assessed at 10 years in the prison. The state is recommending community supervision. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, there been any such motions? Oh, any such motions?
No.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 100 hours of community service restitution. The MIC caseload follow TAP recommendations. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charged in count 1, how do you plea?
Guilty.
And count 2, how do you plea?
Guilty.
And in regards to the enhancement allegation, how do you plea?
Guilty, Your Honor.
True or not true?
Oh, true.
Thank you. State, any evidence to support the plea?
Your Honor, I offer State's Exhibit 1 in the attachments.
Any objection?
No objection.
All right, State, you may continue to confer.
Thank you.
Showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Not at this.
All right, who is Leanne Wright to you?
She's the, I live with her. I live in her back house. She's my landlord. And I
Okay.
live in a studio in the back. She rents it out to me for exchange for work for her.
All right, what work do you do for her?
I clean her house. I'm also a handy person. I do her lawn, cleaning, anything really she needs, shopping, whatever she may need. She's an old elderly person, and sometimes she's an artist. So I'll go get paint supplies or whatever she needs done. I give her 20 hours a week in exchange for room and board.
All right, so other than that, how do you support yourself?
I also work for another artist, and I do the same thing, I do errands or whatever he may need. And then I have a few clients where I do landscaping, handiwork, floating, painting, anything anybody may need.
All right, do you have any children?
No, ma'am.
So when did you start using drugs?
At about 24,
All right, and what drugs did you start with?
I started with marijuana and methamphetamines.
Okay, how often are you using meth?
Was you pretty often,
What does that mean?
a couple times a week.
When's the last time you used? All right, and before you answer that question, there's somebody here who will drug test
Oh,
you
yes.
today.
I don't intend to lie. 4 days ago.
Okay. All right. And is there any mental health issues with you? All right, what are your mental health issues?
I'm bipolar, ADHD, and I suffer from bouts of depression.
Okay,
I do take medication. I'm compliant with my medication, and I see a teletherapist.
okay. And what medications do you take?
I take Wellbutrin, Cymbalta. They just started me on 2 more. I went to the doctor. They started me on 2 more. I'm not sure, one for high blood pressure and another for anxiety, but it's not a narcotic.
All right, so here's the thing. Have you told them about your drug use?
Yes, ma'am.
All right, so the doctor knew that before he prescribed specific medications to you?
Yes, ma'am.
Okay. All right, the court is finding count 1. The court will find you guilty. Court will find you guilty of count 2. The court will find the enhancement true based upon your plea of true and based upon states exhibits 1 and attachments. Count 1 and count 2 will run concurrently. Court will sentence you to 10 years in the prison, suspended and probated for 10 years. A MIC evaluation, that'll be out of custody. TAP evaluation, out of custody. Follow all TAP recommendations. There's to be a referral to felony drug court. Counsel, you need to call felony drug court. They have a graduation that's upcoming. They have a dual diagnosis treatment plan, so that will probably be best for her. But if she's not accepted into that, and if TAP recommends that you go in inpatient, you're going to go in inpatient. You understand? There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be 90 sober meetings in 90 days. And I'm sorry, probation, if you'll change the regular random UAs to the UA hotline. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. Field visits, 1 time per month until in treatment. And just do a referral for Center for Healthcare Services just as a backup plan. And there's to be 100 hours of community service restitution. Probation, is there anything else she needs? Is there anything else you need from the court?
Oh, Your Honor, I'm wanting to check I have insurance, so I was wondering if it would be possible if I check myself into a dual diagnosis facility, would that be acceptable or?
Well, it depends on what dual diagnosis facility you're putting yourself in, because I will tell you, felony drug court is a 2-year program. Sometimes people want to do the VIP, although I think all treatment plans may be VIP. Sometimes people would do these treatment plans where it's 60 days. And since you've been using since the age of 24, 60 days is not going to be enough for you. So if there's some place with your insurance that you want to use, you'll have to get approval from the court to go through that program as opposed to the programs that I've set for you. You understand?
Yes, ma'am. Sure.
All right. Anything else?
No, ma'am.
I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Sure.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You do understand?
Sure.
All right, we can go off the record. Here's the thing, in this court, to be successful at probation, communication is key. If you have an issue, if you think you're about to use, pick up the phone, call probation. That's what they're there for. That's what we're here for. If you feel as though they're not addressing your issue, you can always come back to court. We're here except on holidays and weekends. Okay? All right, good luck to you, okay?
Thank you.
You're welcome.
Thank you.
You're welcome. The next person is going to be Christopher Rodriguez. You didn't do your tie thing.
He didn't know.
Yeah.
He went to the side.
Yeah, he went to the side. You know, when my mom used to discipline us for something that we didn't do, right? My mom was real big on talking to us and communicating. So sometimes she would talk in a louder tone. And then my younger brother would say, "Oh, now I understand." So see, all I had to do was tell him, because I would just keep saying, "Why you're on that side?" All right. Sure. All right, let me sign those. Let me hand this over to them very quickly. All right. Donna, this is two cases. Court is calling, excuse me, 2023 CR 1149, 2023 CR 11150, State of Texas versus Christopher Adam Rodriguez. Can I have parties announced for the record for the state
Hallie Jackson.
defense?
Shannon Walker for Christopher Rodriguez.
And are you Mr. Rodriguez?
Yes, ma'am.
Counsel, have you received all the discovery in each cause number and reviewed that discovery with your client?
I have.
Court will find that the state is in compliance with discovery. Are there any applications?
No applications, Your Honor.
All right. Mr. Rodriguez, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment in each cause number?
We do, Your Honor.
State, are you proceeding on the indictment as presented in each cause number?
No, Your Honor, we're waiving count 2 in each indictment and proceeding on count 1 and the habitual enhancements.
Any objection?
No objection, Your Honor.
All right, Mr. Rodriguez, in each of the cause numbers, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them?
Yes.
In each cause number, you're charged with unlawfully carrying a weapon with a felony conviction. Normally, the range of punishment for that offense is anywhere from 2 to 20 years in prison and up to $10,000 fine. If the state is able to prove up the habitual allegation, then the range of punishment will be 25 years to 99 years or life with a possible fine up to $10,000. Did you understand? If you have a plea bargain agreement with the state, court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent? Did you understand by entering this plea, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in each of these cause numbers? Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He was. He is.
Mr. Rodriguez, has anyone threatened you, forced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand?
Yes, ma'am. I did.
All right. According to the plea bargain agreement, state is proceeding on count 1 in each cause number. Punishments be assessed at 50 years in the prison. There are no applications. The cases will run concurrently. State will take in consideration 2023 CR 10985 and 2023 CR 10984. Did you understand that to be the plea?
There's actually one additional one, Your Honor.
Yes.
Left off 2023 CR 11151.
11151.
Yes, Judge.
Any objection to the court writing that in as a part of the plea bargain agreement, counsel?
No objection, Your Honor.
All right, and then the court will take in, then the agreement is also to take in consideration 2023 CR 11151. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review those paragraphs with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not been, Your
In each of the cause numbers outside the plea bargain agreement, the state is requesting no contact with the complainants. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Honor. Yes, ma'am.
Okay. Then, and cause number 2023 CR 11149. How do you plead to count 1?
No contest.
Into the enhancement allegations? How do you plead? True or not true?
True.
And the cause number ended in 2023 CR 11150. To count two, how do you plea?
No contest.
And to the enhancement, how do you plea?
True.
State any evidence to support the defendant's pleas.
Yes, Your Honor, and each cause number the state would offer states exhibit 1 with all attachments.
Any objection?
No objection, Your Honor.
Mr. Rodriguez, in each cause number, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? Did you sign them in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, police reports, and judgments, but most importantly, there will be no live testimony. Did you understand? All right, in each of the documents, I see the information is signed by Kim Gonzalez as opposed to Mr. Locke.
Yes, Your Honor. Ms. Gonzalez is an associate attorney. I've been representing Mr. Rodriguez this entire time in concert with Ms. Gonzalez. And Mr. Rodriguez consents to that arrangement.
All right, so Mr. Rodriguez, do you need Mr. Locke to go over these documents with you, or did Ms. Gonzalez, who's an associate in his firm, go over those with you, and that's to your satisfaction?
Yes, ma'am, it's my satisfaction.
All right, thank you. In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, if we can go off the record for a moment, if you can mute us, please. Attorneys. All right, any objection to the addition of a judgment and the waiver and consent to stipulation of testimony and stipulations in cause number 2023 CR 11150?
No objection, Your Honor.
If judge at some point while you're clear, can you give indication of the people listed in the no contact text?
All right, thank you. And then in cause number 2023 CR 11149. the judgment 2020 CR 1650. It's what's in the, you have it. No, it's not in there. Yeah, it's in the other one though. No, it happens. No, that's a different one. But that judgment is in the 111501.
This would have to be a bidding judge.
It does? Oh, did I miss it? Thank you. I'm turning so quickly.
You had me doubting myself.
Oh, no, off the record for a moment. All right, any objection to the amendment to the waiver and consent to stipulations and testimony and stipulations and 2023 CR 11149 to have a judgment entered?
No objection, Your Honor.
We have so
It
much
does.
paperwork. I've been there.
I was trying to sort them out this morning.
All right, in each cause number based upon states exhibits 1 and attachments in your plea are true, the court will find the enhancement true, and the court will find you guilty of count 1 in each cause number. Are you proceeding with sentencing?
We could, Your Honor.
Anything you wish to say on behalf of your client?
Only this, Your Honor, there's outside of the agreement, the no contact, there's a young lady by the name of Cassandra in the no contact that is Mr. Rodriguez's daughter. Chris loves his daughter very much and he would like to have contact with her. He understands he will no longer have contact with her mom, but his parents who are here sometimes act as a conduit between the two of them, Chris and his daughter. And certainly Chris does not want his daughter to ever think that he doesn't want to have contact with her or that he would agree to such a thing. So he does love her very much. He wants to be able to do things like send birthday cards to her, maybe through his mom, and keep in touch as best he can under the circumstances that he's going to be under, which are him being in TDC and his daughter being in a different state under the custody of her mom, who will not have contact with Mr. Rodriguez. So what we're asking for, Judge, is the very limited contact that might occur where Chris would send a birthday card to his mom would relay that to his daughter, that sort of thing, just so that Chris can have make sure that she knows that he certainly loves her very much and wants to be there for her, but obviously can't because of the circumstances of the sentence.
State.
Yes, Your Honor. In the case that was, one of the cases that was taken into consideration, the sexual assault, one of the counts in there was endangering the child was present during the alleged assault. It actually happened with her on the bed. She is under the age of 4, and so at this time, we do not feel contact is appropriate, Your Honor.
All right. And that was
That was Cassandra, and then
an
the-
alleged sexual assault
it was
against.
sexual assault against her mother, and then one of the other counts in the indictment was for endangering a child.
And just for the court's edification, Your Honor, there's a lifetime protective order against for Mr. Rodriguez, not for Mr. Rodriguez, but where he is. I think the court understands she is the protected person. He is the excluded person. That's a lifetime protective order with the mom, but he did ask, and the state agreed under those civil circumstances that he could have contact with his daughter.
All right. Is there anything you wish to say?
It's just that I have a protective order in place with the mother of my children, Allison Harris. That's for life. I understand that and completely fine with abiding by that. I just don't see why I need to not be able to have contact with my daughter at all. for the rest of my life.
All right. So I've read the police reports, right? So I'm assuming that you love your daughter. Am I right in assuming that? And you would never want to do anything to hurt her. Hurting her mom is causing her emotional damage. Do you understand that?
Yes, ma'am.
And I don't know why when people go to prison, they expect for people to wait for them. Like nobody is obligated to wait for people when they go to prison. I mean, it's not like the movies where somebody's coming to see you every day at the prison and just waiting at the prison to pick you up and I'm going to be faithful to you. That rarely happens. There are consequences when people make choices. Sometimes the consequence is you go to prison and nobody's waiting for you. It's like, yeah, I'm done. Maybe if you get out and you start acting like an upstanding citizen, we can get back together. But guess what? I don't owe you any fidelity while you're in prison. So all of this started over the fact that you thought that she wasn't being faithful to you while you were in prison. And how long were you gone in prison?
This last time, ma'am?
Mhm.
2 years and 9, 10 months.
All right. So why do people think that somebody should wait for them for 2 years? That's 2 years. And then when people are out of prison, usually they're not faithful, but they want somebody to be faithful for them in prison because technically they have to be faithful because there are no girls in here at the male prison unless they're guards, right? And then we want people to be faithful because we got to be faithful. So here's the thing. She can contact you if she chooses to contact you when she's of age. Right now, I'm not going to order contact. So as previously stated, in each case, I'm finding you guilty. I'm finding the enhancement true. Court is going to sentence you to 50 years in the prison, give you credit for any time served. Cases will run concurrently, take in consideration 2023 CR 10985, 2023 CR, this one, 2023 CR 10984, and 2023 CR 1151. Let me change that in here because it's not written correctly. There's to be no contact with Allison Harris and no contact with Cassandra Rodriguez. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Rodriguez, I realize this is a lot of time. How old are you?
34, ma'am.
All right, you're 34. Here's the thing about having contact with children. At some point, she's going to grow up. Maybe you will get out of prison. You've learned something. You've gotten your life in order. And there's always room that people may have for forgiveness, right? But if you are not doing the right things, then people may not have forgiveness for you. So whether or not she forgives you and ultimately wants to have contact with her father, that'll be completely up to her. But you have to make the first step by doing what's right. You understand? All right, good luck to you, okay? You're welcome.
Thank you, Your Honor.
Thank you.
Excused?
Yes. All right, who's here? Amanda Mahula?
Me, Judge.
Hi,
Good afternoon.
good afternoon. How are you doing?
I'm okay. How are you?
Oh, I can't complain. It is so beautiful outside and I could smell, growing up I never did, but there's a smell from the water hose when you drink water out of the water. That smells so beautiful and brought back childhood memories, that and the smell of fresh cut grass.
Chlorine and pollen.
You can't beat it. All right, so today is your plea deadline date. Where are we?
We're asking for a trial signature.
All right, how long do you expect this trial to last?
A few days.
All right, Ms. Ferguson, it's family violence, 3 days for jury trial on Amanda Mahula. All right, June 4th, is that good for you?
Yes, ma'am.
All right, once you sign the reset form, you are excused.
Thanks, Your Honor.
Yes. Oh, you're welcome. Oh, could you, before you leave, Mr. Montgomery, could you make sure that you have the trial court certification? I'm not trial court certification,
I
the
know what you're
acknowledgement of
talking
discovery.
about.
Yes.
They don't have their folder here right now. We've negotiated it, and as soon as they get it down, we'll get that done.
Okay, sure.
But I'm due down the hall in county court.
Oh, we can do it at trial if there's no other issues with discovery.
There are no.
Oh, well, we can wait and do it at trial time.
Yes, Your Honor.
Thank you.
You're welcome.
I'll bring you your 7 form.
All right, who is here on Rodolfo Lozano? Probation, this is probation case. Court is calling 2018 CR 5872, State of Texas versus Rodolfo Lozano. Could I have parties announced for the record for the state?
Daniel Barr for the state of Texas.
Defense?
Andrew Priest for the defense.
Are you Rodolfo Lozano?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
I did, Your Honor.
Are you the same Rodolfo Lozano who was placed on deferred adjudication in 2018 CR 5872 for the offense of possession of controlled substance, penalty group 1, 4 grams to 200 grams on January 14, 2020 for a period of 4 years? Is that you?
Correct, Your Honor.
Is that you? Yes or no?
Yes, ma'am.
All right, state.
Violated condition number 5 in Bear County, Texas, the defendant Rodolfo Lozano did then and there fail to report to the supervision officer as directed for the months of June 2023 through September 2023 in violation of condition number 5.
How do you plead? True or not true?
True, Your Honor.
Your Honor, state waives all the violations.
Any objections to the waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 5, court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
I do understand, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
I do, Your Honor.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There isn't, Your Honor.
All right, what are you requesting, State?
Your Honor, it's requesting, 62.
All right. Defense, what are you requesting?
Your Honor, we were requesting for him to be continued on deferred, extended, and I believe my client was requesting to be placed on a GPS monitor.
He hasn't done anything.
We recognize that, Judge. I've explained that to my client. He understands. He's had some issues while he's been on probation. He'd been going through quite a bit while he's been on probation. I think my client probably explained that a little bit better than me, but there were some deaths in his family. His wife passed away, his mom passed away. And I think just in him trying to deal with all that, he made some poor decisions when he was on probation. But I think my client can probably explain that a little bit better than.
All right, so here's the thing, before you do your explanation, this is not the first time that you've been here. And I'm the one who placed you on probation, so I know I told you that if there are any issues, you could talk to your probation officer, or you can come to me. And then on March 29th, we had a violation, and that was a violation of number 5. Violation of number 5s are you're not reporting. The state waived other allegations. I found 5 true. I denied it and sentenced you to, and I'm sure this was an agreement, to 15 days in the Bexar County Jail, gave you credit for time served, and there was a judgment satisfied. The state then dismissed County Court Cause number 657003. And then I ordered field visits. And you came in on June 29th, 2021, and I admonished you about staying on top of your probation. At no time, March 2021 or June 2021, did you say, Judge, I'm having some issues with my family, which you could have said because you were standing right before me. Then you came back on December 8, 2022, violation of condition number 5. State waived other allegations without objection. I found 5 true, denied the motion, alternate main conditions to do a TAP evaluation, intensive outpatient treatment, the UA hotline, and transfer to Nueces County. Then now we're back here again. And guess what the violation is? A violation of condition number 5, not reporting. So the court is going to find you guilty. The only question is the time to sentence you to. So does anyone want to address the amount of time?
Judge, we would ask for the court just to consider some of the issues he's been through. He has acknowledged that there were issues while he was on probation. We would ask if the court would consider something towards the lower end of the range of punishment available to the court, 2-3 years.
All right, is there something you wish to say? You want to raise your right hand? Solemnly swear, affirm the testimony you give will be the truth and nothing but the truth, so help you God.
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Docket Lozano.
All right, what would you like to say?
I just want to say that, I mean, I was going through a lot of time and I was grieving for quite a while, and I feel like I'm over that and I'm able to accept the death of my family, able to move on finally and to be the father of my son. My son has been going to church for the past year religiously for every Sunday. We've also been helping feed the homeless every Sunday, and I'm trying to take the steps to be a better father and better role model for my son. I mean, I feel like I'm honestly ready to do this and not just sit here and lie to you. So it took me a while to get over the fact that my wife and my mom died. It's hard to accept that. Like I'm able to move forward from that now.
All right. Any questions?
Not from the concern.
All right, the court is finding you guilty. The court is going to grant the motion, revoke you, sentence you to 4 years in the prison, give you credit for any time served. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand that?
No, ma'am.
You didn't?
I reviewed it, but I didn't understand it.
Oh, so let me just explain to you what a trial court certification of defendant's rights to appeal. If this is a plea bargain agreement, then, and you waive your right to appeal, you don't have the right to appeal because this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is not the fact that you are actually on deferred adjudication. The right to appeal is as it relates to the allegations in the motion. Do you understand?
Not fully.
All right. Well, let me just tell you, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to the attorney. Do you understand that? All right, good luck to you. We can go off the record. Here's the thing. You can only help people who want to be helped. That's all we can do. If you don't want to be helped, can't help you. You understand? Good luck to you. All right, Corey Baumgartner. All right, court is calling 2024 CR 1187, State of Texas versus Corey J. Baumgartner. Could I have parties announced for the record for the state? Defense?
Richard Garcia for the defense. Ready, Judge?
Now, are you Mr. Baumgartner?
Yes.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor, we did.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
Mr. Baumgartner, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Judge.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented? Showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with the offense of evading arrest, detention in a vehicle? That's a third-degree felony. Thank you. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Judge.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Judge.
And did you intend to give up these rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Baumgartner, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, I did.
According to the plea, punishment is to be assessed at 2 years in the prison, and there are no applications. Did you understand that to be the plea?
Yes.
Defense?
Yes, Your Honor.
State? Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Judge.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor, there haven't.
All right, then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence. Any
No
objection?
objections, Your Honor.
State you may continue to confer. Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing states exhibits one and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything
We're
you-
waiting, pre-sentencing investigation.
All right, anything you wish to say on behalf of your client?
Your Honor, we're asking, first of all, that you follow the plea bargain agreement and for the court's information, on this case, Mr. Baumgartner has 108 days of credit. We're asking that you give him credit for the time that he has credit for this case. And on April 1st in Atascosa County, he was sentenced to 2 years in TDCJ and given 275 days credit. And so Mr. Baumgartner is asking if you would give him credit for that time as well. The cost number in that case is 22-02-0022-CRA.
CRA,
Correct.
the letter A?
Atascosa.
Okay.
Atascosa.
All right, so here's my question. So has he been in continuous custody since April 1st of what year?
So April 1st, 3 days ago, he was on probation in Atascosa for a similar offense. And there was a MTR, motion to revoke his probation held, and he was sentenced to 2 years in TDCJ. So that was 3 days ago.
All right, but you're asking for 275 days credit from Atascosa
Yes.
in addition to the,
108 days that he has here.
all right, so the question is going to be comment, Mr. Baumgartner, whether or not was there a motion to revoke pending in this court during those 275 days that you had in Atascosa County? Does anyone know the answer to that question?
Judge, it's my understanding that the motion to revoke came because he was arrested on this case. Is that the case? So he was arrested on December 15th, I believe, of last year. And the motion to revoke his probation.
All right, we're off the record for a moment. So he was arrested December 15th, 2023, correct?
Correct.
And he was arrested on what?
On this new charge here in Bexar County.
Okay. And then I have that all right, so that's December 15th. And when was he in custody in Atascosa?
From December 1st, 2021 to July 6th, 2022. And then
Wait a minute, December 1st, 2021 to when?
July of 22.
So December 1st to 2021 to July 2022. That's when you were in Atascosa.
Spent some time over there on a bench warrant while I was doing this time here.
Okay, so what I can tell you is December 1st, 2021 through July 2022, that's not going to count because this case here, the offense date on this case is December 15th, 2023. So what do we have in Atascosa County?
We were asking to run concurrent with the sentencing there.
Oh, no, I'll run the sentence concurrently, but I'm trying to figure out, is there any time?
The time, Judge, is after the December 15th. And if I'm correct, that's 108 days.
All right, so this is what I'll do. And this is what ends up happening. And we're not on the record yet. I'm just going to explain to you how things work. If you are sent to prison on this, which you will be, right, for your 2 years, if you feel as though the time that you've received is not the appropriate time, that there is more time and maybe the clerk doesn't have the time because they don't have the systems linked up between Bexar County and all the other counties, your attorney can let us know and we'll do a updated judgment. We'll do a not pro tonc. And what will end up happening is those appropriate days will then be put in there. What I can do is I will give you credit for any time served and I'll run the two causes together. You understand?
Yes.
All right, we're back on the record. Court is going to find you guilty, sentence you to 2 years in the prison, give you credit for any time served, and this run concurrent with Atascosa, cause number 22-2, I'm sorry, 22-02-0022-CRA. Is there anything else with regards to sentencing?
No, Your Honor, thank you so much.
All right. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, Judge.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. How old are you?
36.
I mean, isn't it time to stop this?
It sure is.
All right, so here's the thing. You can make a decision. If you want to do Fast and Furious, you know, in the movies, they never get caught. They travel all over the world without passports. They drive off of cliffs, you know, pulling helicopters down with a chain. Unimpossible. I mean, not impossible. I know there is one, this was the jump the shark moment for me. When you have them driving in a frozen tundra, somebody shoots a missile at them, it is going on the ground, and they put their hand out to move it over. Between that and the Rock pulling the helicopter down, you know, just with chain, like, come on. So you're gonna have to stop the foolishness. Otherwise, you're gonna find yourself in and out of prison. Save it for the movies.
Yes, I'm definitely learning humility.
All right, good luck to you, okay?
Or you should join the Formula One, be a race car
You
driver.
should, or either be a stunt person.
Yeah.
Yeah, they'll let you speed
But legally.
legally, yes. Have a
Thank you,
good one.
Judge.
All right, have a good one. All right, who's here on Adrian Delaterio? Court is calling 2023 CR 8848, State of Texas versus Adrian Delaterio. Could I have parties announced for the record for the state? Defense,
Raymond Martinez.
and are you Mr. Delaterio?
Yes, Mrs. Boyd.
Counsel, have you received all the discovery? Did you review it with your client?
I have, Judge.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
I'm going to show you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Mrs.
All right. Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Paragraphs, see on count 2, that's enhanced.
Any objection?
No, Your Honor.
Showing you what's entitled Court Admonishments. Did you review that with your attorney? Did you understand it?
Yes, Mrs. Boyd.
All right. Did you understand the state is proceeding on count 2, which is theft enhancement under $2,500?
Yes, Your Honor.
All right, just one moment. I'm sorry. Someone sent me a text message. All right. It's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Because this is a plea bargain agreement, I'm sorry, just one moment. The text message and the email that I'm receiving. All right, we're back. If you have a plea with the state, court doesn't have to follow your plea. If for any reason I do not follow your plea bargain agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you and you can withdraw your plea. Did you understand?
Yes, Mrs. Boyd.
You understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call,
Yes, Your Honor.
and the right to remain silent.
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
Did you intend to do that and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Delaterio, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Very.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right. According to the plea bargain agreement, you're proceeding on count 2, which theft enhancement. It's theft under $2,500 enhanced. Punishment is to be assessed at 2 years in the state jail facility. There's a $2,000 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is wrong.
State, is that the plea?
It is wrong.
Showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, Mr. Boyd.
Did you understand by signing that you're giving up your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offense and count 2, how do you plead? Guilty, not guilty, or no contest?
No, not guilty.
I'm sorry,
No contest, no contest.
state, any evidence to support the defendant's plea? Any objection?
No, Your Honor.
Going to show you what's entitled, Jason. Going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Excuse me?
Did you understand again that you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we just asked the court to follow the plea agreement and give him credit for the time that he has served. He and I have made taken an exhaustive look at the evidence and the indictment in the case, and he's decided that in his best interest to accept that.
All right. Court will sentence you to 2 years in the state jail facility, give you credit for any time served. There's a $2,000 fine. Time and money are not to run concurrent. There should be no contact with Jennifer Samantha Rocha or Philip Portis, Portis. Let me see. All right, is there anything else from either side with regards to sentencing? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
Can I ask you a question, Your Honor?
Sure.
With all due respect, Your Honor, I was just wondering if there's any way that you can give me an 80-20, ma'am, for this case, if it pertains to your discretion, and I humbly ask you if you can please assist me in that manner. I would greatly
All right,
appreciate it.
whatever, in regards to good time credit, I always consider that when that's sent to me.
Okay, ma'am.
All right,
Thank you, ma'am.
you're welcome. And we can go off the record. Here's the thing. All actions have consequences, right? Do you know when I first started driving? First off, they had full service at the gas station, right? Then they stopped full service at the gas station, and then it was self-serve. Do you know there was a point in time where you could go pump your gas, then go inside and pay? You know why they stopped that? Because people started stealing. They would pump their gas and take off. And so what you have done with that person, guess what? If somebody else comes up to them and they say, I'm in desperate need, I need help, they're not going to trust that person. That person may actually need help. You understand?
Your Honor,
Good luck to you. No excuses. All right, make better decisions, okay? All right, good luck. Who's here on Gilbert Pettis?
Hi, Your Honor.
Yeah.
All right, before we even start, has all the money been paid?
It has, Your Honor. Everything is 100% up to date.
Your Honor, I'm standing in for Chandler from the other part of the DA's office, but that's what he told me before he left, is that the money's been paid to that.
All right, so every single penny.
Every single thing. And he's
And
up to
has he-
date on his fees, etc.
All right, and has he completed his probation?
I believe it's 100% up to date. Judge.
Vashawn, on Gilbert Pettis, has he completed everything?
All financial obligations, and he has completed the programs that.
All right. Court is going to go on the record. Court is calling 2017 CR 7374, State of Texas versus Gilbert Pettis. Can I have parties announced for the record for the state?
Hank Wilkins standing in for Chandler Bowen for the state.
Colin Hobbs for Gilbert Pettis, Your Honor.
All right, and are you Mr. Pettis?
Yes, ma'am.
All right, so we were off the record, and off the record, the probation officer informed the court that the defendant is up to date on his probation and has completed all conditions as of today, April 4th, 2024. And state, has the defendant paid the restitution amount in
Yeah. full?
full?
Yes, Your Honor, Chandler Bowen told me that.
All right, state, do you have any objections to the early termination?
No, Your Honor, I think Chandler told me the official position of the DA's office is that we're standing silent.
Oh, people shouldn't be silent.
It was unopposed, Judge. I can also say that from my conversations with Mr. Bowen this morning, he was under the impression, like I was from our last hearing, that you didn't promise anything, but we left with the impression that should he come up to speed and pay everything, that this was still a hearing that needed to happen, but that we were all expecting it to be granted today. But obviously, I did tell my client that anything can happen and no promises were made.
Okay. All right, then I will grant the motion for early term.
Thank you, Your Honor.
All right, you're welcome. Do not do this again. Do not get caught up in this. You understand?
Your Honor, for the amount, I lost everything. My family, my daughter left South Korea. She used to be proud of me.
Mhm.
I've been very limited in work opportunities, and it's my fault. I don't have anybody else to blame.
Mhm.
But I realized that you lose your dignity, you lose, to me, the right to vote.
Yeah.
It's small things, but I can't take it back.
Mhm.
I can't take it back. I thank you for granting that. And no, I've learned quite a bit.
Okay.
quite a
Well, you
bit.
know, I always tell people, they don't realize when you have crimes that are called crimes of moral turpitude. And I always tell my students, anything involving money, we can go off the record, anything involving money is a crime of moral turpitude. And that affects and impacts your life in so many ways. And I tell my students, one, it impacts you getting financial aid. You may have changed your life, but this still will follow you wherever you go. So I'm glad you've internalized. I'm glad you have accepted responsibility for it. And here's the thing. When you lose family, at some point in time, usually people say, we're family, we're blood. People have changed. You have to work towards receiving forgiveness. Sometimes people don't forgive people unless they consider them as earning it, you know? But I mean, you're still alive, your family's still alive. So what that means is there's still chance that there's for forgiveness. You understand?
Yes, Your Honor.
All right. And thank you. You always would dress appropriately for a court. I appreciate that. All right. Good luck to you. Okay.
Thank you. Your Honor.
You're welcome. Well, just make sure that probation has signed everything off for him. Okay. You're welcome. Specific order, but I wrote it as granted. All right, thank you. Oh, and this is part of that. I'm sorry. Who's here on Darius Harris? Did they enter the plea downstairs?
No, Your Honor, we're well up this before.
All right, let's update. And where's Harris? Hi, come on up. Yes.
So we were unable to enter a plea downstairs with Judge Dominguez. We ran some issues with the plea. We were unable to come to a resolution. I did speak with Mr. Escobar. We are coming to another resolution, but we would request a plea deadline if possible.
Okay. So is there going to be anything worked out with 5 or no?
Potentially, yes. We just have to, I guess, go back to the drawing board with the state.
All right.
Yes.
All right. So when do you want to come back?
Well, he's scheduled again in County Court 6 on the 16th of May. So if you want the day after if it resolves with County Court 6, I would reach out to Mr. Escobar or Mr. Harris to come back. It's up to the court.
All right.
Or the same day.
I tell you what, Norma, can we put this on May 16th?
Okay.
Yes, ma'am. And don't report here first, report to County Court 5 first, okay?
Yes, ma'am.
And I'll write in the file that that's where you're reporting first.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Okay. Thank you, Your Honor.
All right, thank you. And thank you for dressing appropriately for court.
Thank you.
Yes, May 16th. All right, who's here on Anthony Warrington? All right, court is calling 2024 CR 1021, State of Texas versus Anthony Leroy Warrington. Can I have parties announced for the record for the state? Defense?
Carl Basley, Your Honor.
Are you Mr. Warrington?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Warrington, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, since we have California
Any objection?
No objection, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. I can't see. I'm sorry.
That's okay. Did you review a document with your attorney entitled court admonishments and defendants waivers and affidavit of admonitions?
Yes, ma'am.
Did you understand that in count 2, you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea, or gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, court could find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
And he's currently competent and was saying at the time.
Mr. Warrington, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on count 2. Punishment is to be assessed at a cap of 8 years in the prison, and the state is silent on your application. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The
Yes,
only
ma'am.
items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State any evidence?
State all proceeds to the one and all aspects.
No objection, Your Honor.
All right, did you review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. All right, state, when can a TAP evaluation be completed in custody?
Your Honor,
Judge, 2 weeks.
the only issue I need to bring to the court is he had filed an pro se writ habeas corpus as far as being in the jail longer than 90 days, and I filed a notice to incorporate that, and you said you were going to bring that up Tuesday when we're back, but he wasn't here. So I
Okay.
didn't bring that to the court. I was going to ask for TAP evaluation too.
All right,
I think
so
that-
this is what we're gonna do. We're gonna do a TAP evaluation in custody. Ms. Ferguson. Can you recall this? They said they'll have the TAP evaluation done in 2 weeks. Where does that put us at?
The week of April 15th.
All right, so can we recall this back? On April 18th, that's not enough time for probation, is it?
Judge. That's gonna be pushing it, Judge.
I already have 4 cases set that morning, it might be tough.
All right, so Norma, then we can bring it back on the 19th or the 30th. Unless you all want it back on the 22nd. I won't be here, Judge Angelini will.
I want to get as soon as possible, right?
Well, no, not the 19th.
Oh, okay.
22nd.
Oh, Well, that's just it.
That was what you said,
I
right?
thought just the
Yeah, you can do it the week of the 22nd, but I'm telling you, the week of 22nd, I will not be on the bench here. It will be Judge Angelini. The only other choice is the 29th or the 30th.
Okay,
So when do y'all want it set?
29th is fine. We're down to other cases, Your Honor.
All right, so Norma, we're gonna recall this back on the 29th. And we'll do a TAP evaluation in custody. Usually, Mr. Warrington, it takes 6 to 8 weeks, but because I'm just requesting a TAP evaluation and state on the 29th, if you all can have the criminal history available for the court, that's what I would need.
And I will have a couple witnesses, Your Honor.
Okay. All right, so Norma, it'll come back on April 29th. And then what's your other issue, counsel?
Your Honor, the other issue is the writ of habeas corpus that he filed, pro se, claiming that he was in custody more than 90 days before he was indicted. And asked if I would incorporate his file and notice of adoption of that. He was arrested on October 19th.
Okay, so before we go into that, have you talked to the state to look in the system and see if everybody is in agreement on those time?
No, I've not talked to state.
All right,
but
so-
the date of the indictment is clear. It's only-
Here's the thing, I'm here, I'm not going anywhere. Just talk to the state, see if they agree on those dates, then we can that'll make things move more quickly. They're here, I'm here, I'm not going anywhere.
And then you want to put it at the.
Do you want-
Yeah,
Or somebody just.
oh, it's sentencing on the 29th.
No PSI.
No, just need a TAP evaluation.
That's a holiday. Right here, if you want it. I already explained that to him. We're now the courtroom. Go ahead. My mistake. Nineteen. Yeah. Yeah, 17, 151.
Jason. This is what Norma sent me.
Yes, please.
All right.
What I do, did I give you the plea by mistake? I'm sorry.
I know you haven't given me the plea paperwork back.
What I do?
Who has the plea paperwork?
Oh, you had that plea paperwork? I'm looking for it.
It's not in the file.
Oh, it fell down here. I know I had it in my hands. Okay, let me initial real quick. You need to initial. Okay. Yeah.
All right, we're back on the record. In 2024 CR 1021. It's the court's understanding that there has been an addendum or an amendment or addition to the plea bargain agreement. And the amendment is as follows: that the defendant will be open to the full range of punishment if he fails to appear for sentencing. Did you understand that if you fail to appear for sentencing, then you will be subject to the full range of punishment, and that range of punishment is up to 20 years in prison and up to $10,000 fine?
Yes, ma'am.
And is that the agreement, the entirety of the plea bargain agreement, state
Yes, Your Honor.
defense?
Let me ask you some real quick, your mind now.
Sure. We're not on the record, Diana. All right, we're back on the record. Did everybody understand that to be the plea, state, and defense?
Your Honor, that's a request from the state and the court. Talked to my client, I just talked to him. He's going to do that. Yes, I can get the testimony. I can get you testimony. Yeah. Okay. Oh, that's just. Okay.
All right, so everybody understands that's the plea, state, defense?
Yes, Your Honor. Yes, Your Honor.
All right. Now, with regards to the defense's motion, the defense is adopting a motion that has been filed. And it's a request for a PR bond or amount of bond that the defendant can afford because the defendant was confined for more than 90 days before the indictment. State, do you stipulate that the defendant was confined more than 90 days before the indictment?
Yes, Your Honor.
All right. So then, you are entitled to a bond that you can make or a PR bond. Off the record, the defense counsel informed the court in the state's presence and with the defendant present that there are family members who can make a bond of $5,000. Is that correct?
Correct, Your Honor. The
All right.
family members in the back, I talked to them and that's what they said they could make.
All right, if you want to call a,
Second.
all right, if you want to call a witness. All right, can you raise your hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Brianna Wilburn.
I'm sorry, what?
Brianna Wilburn.
All right, defense.
Ms. Wilbur, can you tell me the relationship you have with Mr. Warrington?
He's my ex. We've been on and off talking. We haven't talked for about a little over a year before we talked again, and we had stopped talking for a while.
So
So
currently you and him are in a relationship? Okay. And how long has that been? You said a year, I mean.
yeah,
recently?
we broke up for a year. We got back together.
Okay. And you know why the judge will have hearings today for the court? As far as the bond?
For the most part.
Okay.
Yeah.
Okay. Tell the court what kind of money you make.
I work as a home health caretaker. My mom, she's injured and she's medically she has to use a walker. I take care of her. I get paid every bi-weekly, if not every week.
And how much do you get paid?
Anywhere from 400 to 600.
And What, you have housing expenses and food and transportation expenses?
Yes.
Okay, how much do you usually pay out in a month?
Well, I do the medical rides, so I don't really have to pay for those. Monthly, I don't know, maybe. Yeah, I don't know.
Well, let me just ask you this, like, after the month's over, how much do you have money left for what you made?
A little over 1,000.
You have $1,000 each month?
All right, you need to respond either yes or no.
Sorry?
You need to respond yes or no.
And I asked you earlier what kind of bond you could afford, and you told me it's $5,000 a month. And why did you say that?
Because right now, the money, I still have to pay my rent and the money's,
That's what I'm asking.
Yeah.
After your rent, what can you afford?
yeah, the $5,000 bond, so the 500.
Okay, that's well. Because you said you had $1,000, I want to make sure after you pay your rent and everything else.
Yeah.
Okay, so you have enough money left to pay, would be $500.
Yes.
Can you afford that?
Yes.
Can you afford anything more than that?
Maybe I might be able to, yes,
Might be, but you're not sure.
yes, because I have to, all the other payments.
No further questions, Jimmy.
All right, let's go off the record for a moment. Can you stop video, please?
Yes, ma'am. Audio too? Yes.
Questions?
I guess it's just, so how did y'all come up with the $5,000?
I'm sorry?
My name is Hank Wilkins, I'm one of the prosecutors.
Okay.
And so we've been trying to give the judge information about is the bond amount that Mr. Warren can make. You're gonna help him do that, right?
Yes.
Okay, so how did y'all come up with?
Well, me and his brother are, yeah.
And his brother, okay. So how did y'all come up with the $5,000?
Well, I still have my car payment and my rent payments that I have to, so I have to, like, I added in all my expenses that I have to take, subtract that from it. That's how I came up with that.
Okay.
Yes.
And what's his brother gonna put into that?
We haven't fully discussed that just yet. We were about to before I had just called up here, so.
So is the $5,000 just something that you? I guess I'm just kind of fuzzy on how you came up with that.
What do you mean?
How did you come up with that?
Like I said, I had to subtract my expenses, like my car and the rent. I have my dog that I gotta take care of. I need stuff for myself, stuff for the house. So I gotta subtract all those expenses too.
Thanks. I'll pass it with this one.
All right. And I'm sorry, what is your full name again?
Brianna Wilburn.
How do you spell your last name?
Well, it's BRYANNA.
BRYANA?
NNA.
NNA. And how do you spell your last name?
WILBURN.
All right, thank you. Hi, can you raise your right hand?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Athens?
All right, defense?
Could you tell the court your relationship to Mr. Warrington next?
This man, I call my brother. I've been knowing him for like the last 15 years.
So he's not really your blood brother,
No,
he's
he's not
really
my
close
best
friend.
Really close. One of my best friends.
And you say you've known him 15 years,
Mhm.
all right, and how do you know him?
Yeah. We were introduced to each other in Haven back in maybe 2010, 2011. He's been a friend ever since. His first day there was one of my first weeks there.
Okay, so you went to Haven with Hope and you had issues, okay. So the court, did you have any concerns? Did you have to work on any issues at Haven?
No, not really. I didn't stay at Haven too long. I became recently homeless there and I kind of freaked out because I had no bill insurance.
Now, the court's trying to figure out what kind of bond you can provide and what can be provided. Are you willing to assist his girlfriend in putting money together for a bond?
Yes, my employment situation, I am a full-time employee at Coyote Ugly. I work 6 days a week, I make $16.50 an hour, and I can help.
Okay. But you have any expenses too?
Oh, I have my expenses, yes.
Okay, so how much free money would you have approximately at the end of the month?
At the end of the month, I don't know, it depends. I have a daughter that's in high school, it depends how much she takes from me. But usually I paycheck, we bring home between 11 and 12 every week. And weekly expenses, I might have 200 or 300 left over.
And you would be able to come up with $500 instead of close to $5,000 bond, correct?
No problem.
Okay. And if the judge has some concerns about where he's staying, if he got released on bond, would you be able to stay with you?
Staying with me, I don't know about this. Staying with me because I stay with my daughter and her mother,
okay.
but
Okay, just wanted to ask.
adequate situation, I can find him somewhere. If I have to pay for a room, just him to be in, I can help it. I know Miss Boyd doesn't remember me, but 2010, I remember her from being in drug court. I'm one of Judge Glenn's people, so I graduated, so I do remember you back then.
Okay.
No further questions.
All right, any questions?
Yes, ma'am. Hi, how's it going?
Excellent. All right, nice to meet you.
So we're trying to give the judge some information about what to set the bond amount at. How much do you think we can help Mr. Warren contribute to his loss?
I mean, depending on what she comes up with, basically is, I'll put in the rest or the number, the 5,000 number, it was just a number he threw out there as a number. Yeah, we can do that. That's how we agreed upon that. It wasn't nothing discussed in length or calculated, tabulated, just a number that he put out.
So. Would you fair to say you could contribute like $500?
Contribute. I don't know if you see what's happening behind you. And it seems like I might be doing more than just contributing. I'm sorry.
No, I'm talking about my arm gets red.
Thank you. I don't have other questions.
Any other questions?
I don't have any questions.
All right. All right, thank you so much for coming in. All right.
nothing Further on
No problem.
after what happened.
Well. All right, so this is what the court is going to do. Court is going to set the bond at $5,000. There should be no contact with Brianna Wilburn. You return back to court. Norma, if you can make sure that he make sure that he gets a reset form. Let's see. And if you all just remain here, because they'll see if there's some items that she wants to give to you all, okay? All right, any other conditions? There's going to be UAs, random. And I'm going to order 90 sober meetings in 90 days. And then, Mr. Warrington,
Yes, ma'am.
have you ever had any type of mental health diagnosis for anything?
No, I just seen mental health at the jail. And when I first came in, they put me in a 3-day, observation thing, and they let me out, and I've been a general pop ever since. And the lady who runs my REMS class, I just went to see her last Friday, I believe it was. And she said she got me diagnosed with depression, PTSD, without suicidal or homicidal. I forgot how she worded it, but I mean, in other words, I mean, I'm good. I'm okay.
Well, I'm gonna also order a referral to Center for Healthcare Services. So when you're released, you need to start doing your sober meetings, okay?
Yes, ma'am.
And you need to do a sober meeting a day.
Okay.
And then you need to, there's gonna be a referral for Center for Healthcare Services, okay?
Is that the one over there on?
It used to be on Brady, but it's not there anymore. Let me see.
Over on Babcock, I believe that's from up around in that area.
Let me see.
Judge, are you gonna order GPS?
Just one second. Oh, no problem.
Oh. Yeah. Okay, that's fine. All right.
All right,
Sooner or later.
sir, you have one that's on North San Saba. Also one that's on West Commerce Street. And then you have one that's on North Main Avenue. But if you call them, pick up the phone, you can call them and they'll set up an appointment for you, okay?
All right.
All right, and then we can do GPS, waive fees, and that'll be done through the jail.
Yes, ma'am.
All right.
Is that gonna be partial, Your Honor, or full? I don't know where-
I'll do GPS waive fees, GPS partial for medical appointments and for work. All right.
Ma'am.
That's fine.
Thank you.
All right, thank you.
I appreciate it.
Welcome. Norma, I have no idea the answer to your question. Okay, that's fine. Dinah.
Yeah, that's out, that's out.
Yes, Norma does. Okay. Oh, that's okay. Hank would probably know. Yeah. Okay, are you ready or you need some time? Mhm. Yeah, oh, I think he's fine. I didn't get those vibes from him. All right, who's here for Timothy J. McCormick Johnson?
I am, Your Honor. Acknowledge for Mr. Johnson.
All right, Diana, you ready? All right, court is calling 2024 CR 3084, State of Texas versus Timothy J. McCormick Johnson. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
What a heck analysis, Mr. Johnson.
And are you Mr. Johnson?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I have and I have.
Court will find that the state is in compliance with discovery. Mr. Johnson, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving it. That's what paragraph.
All right, any objection?
No objections, Your Honor.
Showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do believe that, Judge.
Mr. Johnson, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State recommends community supervision. There's no application for deferred adjudication. They're taking in consideration night mag number 757-662, 757-661, and there's to be restitution to SAPD for drug testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
They have not.
Outside the agreement, the state is requesting that your community supervision be for a term of 10 years. There be a TAP evaluation, 250 hours of community service restitution, and for you to be placed in inpatient treatment. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Yes, ma'am.
State any evidence
No objections, Your Honor.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of written witnesses' statements and police reports? But most importantly, there be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court would defer, I'm sorry, you're not applying for deferred adjudication, so the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask that the court follow the agreement with the state and Mr. Johnson wants to better himself. He's not working at present, but he'd ask that because of this financial situation, the court probate the fine in this case.
All right.
And he's also interested in going to lifetime recovery, Judge, if that's possible.
Okay. All right, Mr. Johnson,
Yes, ma'am.
who is Ashley Hewitty, Hewitty Almanza to you?
I have no idea, ma'am. I don't even know who that person is.
All right, and who is Rudy Gomez?
I have no idea, ma'am.
And who is Mallory, Malarie Garza?
I did.
All right, so how long have you been using drugs?
Methamphetamine, I probably started in my late 20s. I just turned 40 last November 4th.
All right, do you have any children?
I don't know, ma'am.
All right, who is your support system? You have mother, father, who?
No, I lost my mom I lost her 2014. I grew up without dad, I'm the oldest of three. So it's really, I depend on myself, you know what I'm saying?
I'm sorry, you said you grew up without a dad and
Yeah, I
then,
grew up without dad, lost my mom to December 26, 2014.
and so you're the oldest out of three?
Out of three, yes, ma'am.
All right, have you ever been employed?
I have.
Doing what?
Concrete. I work for, I don't know, I mean, I got a job, but my boss told me I need to get a phone, that way he can get a hold of me. Because like, he can't quite put me back in there, like, you're gonna take time for me to get back and work, because I've been in jail and all that stuff, and you know what I'm saying, but I've been on my boss for over 10, 15 years, and he's always been there for me. He just wants me to basically better myself, get a phone so he can get a hold of me, so he can get me back into work. And then
All right, this is what the court is going to do. Court is going to find you guilty, sentence you to 10 years in the prison, suspended and probated for 10 years. There's a $2,000 fine that will be probated. Take in consideration NIGHTMAG number 757-662, 757-661. There's to be restitution to SAPD for drug testing, a TAP evaluation in custody, follow all TAP recommendations, a referral to felony drug court, although I don't think they will accept him based upon his history. And that's to be done in custody. There's to be no contact with the following persons: Mallorie Garza, Malarie Garza. Frank Medina. Ashley Nicole Hewitty, Hewitty Almanza. Rudy Gomez Jr. There's to be regular reporting by Zoom or in person. The UA hotline.
what is that, Judge, if you don't mind me asking?
Oh, that's where you end up calling in and they'll let you know whether they want you to test or not. 120 sober meetings in 120 days. Proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. Field visits one time per month until in treatment. And MIC evaluation can be done out of custody. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
I was asking to go to the lifetime recovery, but I don't know, I don't know, because.
All right, so here's the thing.
Like, I got through my chaps last time, and
Here's the thing, lifetime recovery, that's a great program. However, you can't pick your own program. You know why? Because if you could do your own program and write your own program, we wouldn't be here.
Yeah.
So we're going to follow whatever TAP recommendations they want for you. But I know it's going to be a form of inpatient treatment, and you need to be honest with them about that. Otherwise, you're not going to be successful on probation. You understand?
understand that.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorneys? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's the thing. In order to be successful on probation in this court, you need to communicate. If there's an issue, let your probation officer know. If you feel like they're not addressing it, you can always come into court, okay? All right, you're welcome. Good luck to you.
Maybe just now.
Yes. Who? Okay, sure. And do we have any other files left over there?
One.
And that's Dustin Newkirk.
Correct.
All right, could I see that file?
Judge, do y'all also have Andrew Estrada?
Well, we have.
Oh, yeah, we have the plea paperwork on that.
It's like that guy.
Thank you. All right, can somebody check? Mr. Estrada, is he in custody somewhere? Is there a warrant out there? I'm sorry, Dustin Newkirk. I see you, Alabama. He shows up late to court and he comes wearing Alabama gear. Guys, he comes to court wearing Alabama gear in Texas in front of a LSU judge. What are the chances? All right, can you check to see on this case? Is a warrant out for him? Is he in custody? Are you ready? All right, court is calling 2024 CR 0350, State of Texas versus Andrew Thomas Estrada. Can I have parties approach and announce for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Anita Perez for the defense.
And are you Andrew Thomas Estrada?
I'm Andrew Thomas Estrada. Yes, ma'am.
All right, counsel. Have you received all the discovery? Did you review it with your client?
Yes, we have, Judge.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Right. Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Did you understand you're charged with evading arrest, detention in a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I do.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am, I do.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am, I do.
Counsel, has your client been able to provide any defenses for you?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I believe he is.
Mr. Estrada, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, we went over it.
All right, according to the plea, punishments be assessed at a cap of 7 years in the prison, and the state is silent on your application for community supervision. Did you understand that to be the plea?
Yes, ma'am, I do.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am, I understood it.
All right. Council, are there any such motions?
No.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
I plead guilty.
State any evidence.
Your Honor, I offer State's Exhibit 1 in the attachments.
Any
No.
objection?
No objection, Judge.
Showing you what's entitled waiver and consent to stipulation and testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am, I did.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. So we can go off the record. So what I'll need in this case, TAP evaluation, of course, and criminal history, unless you want a full PSI. If you want a full PSI, it's probably going to take 8 weeks.
It's,
I mean,
So he's on supervision in, what did he say?
in San Patricio County, Judge. And I've made that aware to the state, and I'm happy to forward them that information.
So if he's granted community supervision, I think that he would want to transfer supervision to San Pedro.
That's correct, Judge, because that's where
Alright.
he lives, that's where he works. I was
So,
hopeful, and my client does drive in from San Patricio every time, so I apologize if I'm being tardy.
Oh, no, there's no need for you to apologize for him. He knows.
It's my fault.
Yeah, yeah, it's his fault. He knows how long it takes to get from there to here, and there was no eclipse.
Oh, ma'am, there was not.
So
Next
it's,
week.
let him accept his own thing.
Well,
All right.
I mean, I just wanted to make the court aware that, I mean, he's been driving, so I was hopeful that we would get this taken care of today, but, as far as your question of full PSI, I don't believe it's necessary, Judge.
All right. So,
His criminal history is very limited.
all right. So Ms. Abrams,
Yes, Judge.
how long would it take to get a TAP evaluation for him out of custody?
2 weeks, Judge. I mean, out of custody.
Mm-hmm.
And then he's in,
3 weeks, Judge.
All right. I'm gonna give you 3 weeks. Let me ask you this. If we recall this for the 29th? All right, we're gonna come back on April 29th.
trying not to come back on the 29th. I haven't put a vacation letter on file.
Oh.
But my daughter has a volleyball tournament Saturday, Sunday, and Monday in Houston.
Oh, so will you be back on the 30th?
Yeah, the 30th is fine.
All right, so April 30th, Norma?
Yeah, that's fine.
All right, so we'll come back on April 30th. On April 30th, there will be a TAP evaluation that will be completed. And state, I'll need the criminal history and I'll make a decision.
Yes.
And I'm telling you right now, on April 30th, you need to be clean when you come to court. You understand?
Yes, ma'am, absolutely.
All right.
And he has been, Judge. I shared that with the state, that I got I'm gonna have the probation file from San Patricio as well
Okay.
for the court.
All right. Once you sign the reset form, you're excused.
I'll
Are
see
you gonna
April
come back
30th.
on April 30th wearing Alabama gear?
No, ma'am, I will be dressed appropriately for court.
No, you dressed appropriately for court. I joke.
Just have a seat. I'll have to put you-
So Norma, on Dustin Newkirk, does he have a bond or not? Does he have a warrant or not?
I do have it.
Okay, thank
Attorney.
Okay. All right, so state, we're gonna be back on Friday. We have 3 cases. We have,
Gotta give you an updated one. I added one more.
okay, so we have 4 cases.
Jason Todd is asking me if we have docket tomorrow, so maybe he's gonna try and bother us.
No one else comes. Yes. Let me see the file on that.
It's already in mental, it's been.
Oh, but was she ever placed on probation or did a plea? That's the thing, because if she did, we'll have to do a motion for new trial. All right, if you can check to see if that's not the case, then.
For that word.
Mhm.
Motion for bond. So that's when you bring.
All right.
That's why he's out. In your letter, even though the motion.
Okay, all right, then she doesn't need to come. State, Renee Gardia, she's been accepted into the mental health court, so that's done. So that's on Friday's docket. Then the other thing we have is Darwin Gomez, the Jesse Inaho, that's with family violence. And Jonathan Lopez is a robbery case. I'm assuming that's yours. And then we'll be back tomorrow at 9 and hopefully